Hello everyone, and welcome to the March 2023 episode of My PIP Monthly. As always, my name is Amber Rouse Holloway, and I'm a partner here at our Troy office. Our March 2023 topics include a case law discussion, a case law update, as these are all new opinions that have been issued through our Court of Appeals. First, we'll start off with Advanced Therapy and Rehab v. Auto Owners. This is a soon-to-be published opinion. The next, we'll move on to Simone Johnson v. Suburban Mobility Authority for Regional Transportation. This is an unpublished opinion that was issued this past February. And then lastly, we will leave off for our case law update with the Farah v. Smart soon-to-be published opinion. Then, of course, we will move on to trending topics in PIP litigation. And we received some requests to talk about some litigation management strategies for pre and post lawsuit issues. So I'll discuss some ways that we typically see, some issues we typically see, and how to manage those issues pre and post suit in litigation. All right, first up is the case of the soon-to-be published opinion of Advanced Therapy and Rehab v. Auto Owners Insurance Company. This case centers around, argues that an insured must treat with in-network providers, and that was a common defense and coordination of PIP benefit cases that we saw. But according to this soon-to-be published opinion, whether a provider is in network or out of network is not an automatic disqualifier for secondary auto payment. So what we would typically see, we would get a case and we would notice that there, pursuant to the applicable policy, there was a coordination of benefits clause. And then the provider that was treating, in this case, it's Advanced Therapy and Rehab, would submit their bills to the claimant's health insurer, whether it's the case here is Cigna or Blue Cross Blue Shield, and then the bill would be denied because the provider is out of network. Now, prior to this case, once that bill was denied and the health insurer says it was out of network, the auto insurer now has a defense that pursuant to the contract, they should have treated with an in-network provider pursuant to this coordination of benefit clause. And because they did not treat with an in-network provider, the auto insurer has no obligation to pay that benefit or to pay that bill. Now in this case, we have the claimant. His name was Andre Iglesias. Of course, he was involved in a car accident. He then sought treatment with plaintiff here, Advanced Therapy and Rehab. He did have the coordinated no-fault policy with auto owners here, and he did have a health insurance policy with Cigna, and that was a PPO plan. The Cigna plan provided coverage for in-network services and out-of-network services, but services by in-network providers had a lower annual deductible and a higher reimbursement rate. Now, services by out-of-network providers had a higher annual deductible and a lower reimbursement rate. Advanced Therapy, the specific provider in this case, was out of network under the Cigna policy, but it's important to note that Iglesias, the claimant, did execute an assignment of benefits, allowing Advanced Therapy to recover payment for their services. So the plaintiff here, Advanced Therapy, sent their bill to Cigna, but it was not paid because the provider was out of network and Iglesias had not met his deductible. So if he had met his deductible, it would have been paid. Cigna did apply the amount billed by plaintiff to the deductible, but it wasn't paid because they had not met the deductible. Advanced Therapy then sent the bill to auto owners, but then auto owners refused to pay the bill, even though Iglesias elected to receive excess medical coverage under his auto owners policy. The coordination of benefits provision in the auto owners policy stated that benefits would only be paid in excess of other insurance after Iglesias received treatment from a provider covered by Cigna, and Iglesias sought payment for treatment from Cigna. Plaintiff sued auto owners pursuant to the No Fault Act, of course, and auto owners filed a motion for summary disposition, but it was denied. This appeal then ensued after that. Now here, first the Court of Appeals found that because this accident happened before the 2019 No Fault reform, the older version applied. Also, it was undisputed that Iglesias chose to coordinate his benefits between Cigna and auto owners. On appeal, auto owners argued that when a person elects to coordinate primary health insurance with secondary to PIP coverage, The decision in the two Signat v. Allstate Insurance Company case required the person to mitigate out-of-pocket expenses by seeking treatment that is maximally covered by the primary insurer. In this case, it would be Cigna. The court here did not agree with the interpretation. Instead, the court found that the key to two Signat turned on the fact that the person had health insurance through an HMO, which is different than the PPO the claimant Iglesias had here. Now, generally, just by way of background, HMOs have cheaper premiums, deductibles, and cheaper charges for services. However, HMOs restrict which providers it covers for medical services, and that's how they're able to have those cheaper deductibles and premiums and charges. In contrast, the PPO provides more choices for providing medical services, but PPOs are more expensive. Now, in the underlying case of two Signat, which is important here, the insured's insurance policy was an HMO. That meant that the insured had to seek treatment from HAP's in-network designated providers. Further, nothing in two Signat required an insured to minimize the cost to a secondary no-fault insurer, but maximizing the amount the primary insurer would cover. In this case, Cigna was a PPO and not an HMO, and the Cigna policy provided coverage for out-of-network services, even though such coverage was subject to a higher deductible and lower reimbursement rate than the in-network services. Advanced therapy services here were covered by Cigna, but the bill was not paid because the deductible was not met. Therefore, claimants sought to obtain payment from Cigna to the extent health coverage was available. Now, by applying the billed amount to his deductible, Cigna provided coverage, just not reimbursement to the provider. And therefore, under the auto owner's insurance policy, Iglesias was required to treat with providers that were covered by Cigna and seek payment by Cigna, which he did. Therefore, auto owner's motion for summary disposition was properly denied according to our Court of Appeals. And just some takeaways from this one. The law here never required an insured to maximize health coverage to minimize expenses to an auto insured carrier. That's not their job here. It only requires for an insured to follow the coordination of benefits provisions in the auto policy. Therefore, assuming that insured does follow all the requirements by treating with a covered provider and then seeking payment is enough to trigger payment from the secondary auto carrier where the health insurer does not pay. And of course, auto carriers with similar coordination of benefits provisions and policies will run into situations like this now that this binding case has been decided. Again, this is not an unpublished opinion and will be binding. Next up, we have the case of Simone Johnson, the Suburban Mobility Authority for Regional Transportation, better known as SMART. Again, this is an unpublished opinion per the Court of Appeals and was issued recently on February 16, 2023. Now, this case centers upon the idea that to overcome a presumption of negligence that's generally built into rear-end collision by the claim of a sudden emergency or using the sudden emergency doctrine, the driver of the vehicle must establish that peril, that sudden emergency, was not in clear view for any significant length of time, and that peril, that sudden emergency, was not brought upon by the driver's own negligence. Now, this case centers upon a 2018 accident where the plaintiff was a passenger in a SMART bus that was driven by the defendant, Ronald Presley. And this accident happened during rush hour traffic in the middle of the summer. At the same time, there was another defendant, Shane Webster, who exited a parking garage, and then subsequently, Mr. Webster passed the SMART bus driven by Mr. Presley in the left lane and activated his turn signal. Mr. Webster believed that Mr. Presley saw his turn signal activate, namely by slowing down and implicitly offering Mr. Webster a chance to change lanes in front of the SMART bus. Based on the same, Mr. Webster changed lanes in front of the bus. However, traffic in front of Mr. Webster suddenly stopped, and then Mr. Webster was forced to slam on his brakes. Mr. Presley was unable to apply the brakes on the bus in a cleared and assured distance and ultimately rear-ended Mr. Webster's Chevy Cruze. Now, inside the bus, Miss Johnson, the plaintiff, flew forward, struck her head, and was thrown back into her seat. Miss Johnson was taken to the hospital by ambulance to treat her injuries. As a result of the accident, obviously, Miss Johnson sued Smart, claiming that the bus driver, Mr. Presley, negligently controlled the Smart bus, which caused her injuries. Smart moved for a motion for summary disposition, arguing governmental immunity and that there was no genuine issue of material fact. Notably, Smart argued that it was entitled to SD under MCR 2.116 C10 because there was no question of fact regarding Mr. Presley's negligence. Now, the statute that is on point here is MCL 257-402A, which states that any action in any court in the state, when it is shown by competent evidence that a vehicle traveling in a certain direction overtook and struck the rear end of another vehicle proceeding in the same direction or lawfully standing upon any highway within the state, the driver or operator of such first mentioned vehicle shall be deemed prima facie guilty of negligence. Basically, all that's saying is in a rear end accident, the driver that rear ends the other vehicle in the state of Michigan is negligent, and you can presume that negligence. Now, despite the presumption of negligence built into Michigan's rear end collision statute, Smart contended that it should be relieved of liability based upon a showing of adequate excuse or justification. Specifically, Smart relied upon the sudden emergency doctrine here, or sudden emergency exception to the statute. After considering the briefs and oral arguments, the trial court agreed with Ms. Johnson and denied Smart's motion for summary disposition, and this appeal followed. Now here, the Court of Appeals expanded on the sudden emergency doctrine, providing that to come within purview of the doctrine, the circumstances surrounding the accident must present a situation that is unusual or unexpected. Turning to the case at hand, the Court of Appeal noted that two problems with Smart's arguments existed regarding the sudden emergency doctrine. One, the court indicated that an essential part of the doctrine is that the potential peril had not been in clear view for any significant length of time. The court believed an issue of material fact existed whether this potential peril related to Mr. Webster's Chevy Cruze had been in Mr. Presley's clear view for any significant length of time. Consequently, for this reason alone, the court found that there was a question of fact whether Smart could rebut the presumption of negligence. Second, the court mentioned that Smart's reliance on the sudden emergency doctrine involves allegations related to Mr. Presley's negligence. The court reiterated that the sudden emergency doctrine does not apply when the emergency in which the driver finds himself is brought by his own negligence. Here, the court stated that Mr. Johnson had presented evidence creating a genuine question of material fact as to whether the sudden emergency here faced by Mr. Presley was caused by his own negligence. Therefore, again, the court found that Smart's reliance on the sudden emergency doctrine did not entitle it to summary disposition. Ultimately, according to the court here, there was no evidence of a phenomenon of nature, but instead the record simply showed that everyday traffic routine confronting Mr. Presley. As such, the court found that the circumstances were not unusual, especially meant under the sudden emergency doctrine. Further, the court found that there was at least a question of fact regarding whether a jury could find that the circumstances were unsuspected. Therefore, for that reason, the court found that Smart was not entitled to summary disposition. Next up, we have the case of Farah v. Smart again, and this is going to be a soon-to-be published opinion, so will be binding moving forward. Now here, this case, the important takeaways from this case are that when a person injured in an automobile accident grants assignments to their medical providers, the providers become the real parties of interest with respect to their claims, and they can sue, meaning the providers can sue to recover those benefits. Further, as to the 1-year back rule, the Court of Appeals panel noted that Focus Imaging's intervening complaint was clearly too late to preserve the bills at issue. Here, it's important to note that the services at issue were provided in March 2019, shortly after the accident. And this case was filed, obviously, more than 1 year after that date. Lastly, because the providers/assignees hold a separate legal right, the intervening providers in this case were considered new parties, and therefore their intervening complaints did not relate back to the original filing date for purposes of the 1-year back rule. Now, it's important to go into some background in this case. As we all know, the role in assignments and first-party no-fault cases has continued to grow since the Covenant opinion, which it's important to note that although providers do have a direct cause of action for services rendered on or after June 11, 2019, the assignments protect providers from claim preclusion if the insured person were to bring their own suit later. Another case on point as to this issue is the Mecosta County Medical Center v. Metro Group Property and Casualty Insurance Company, which indicated that assignments can also, in certain situations, allow providers to avoid a good faith payment defense under MCL 500-3112. And that's also described in the Physiatry Rehabber v. Al-Halemi case. And I believe Secrest Wardle has done a no-fault newsline on this issue as well. So for more detailed and a written, if some of you are people that need to see things visually instead of just listening to me talk, there's a very thought out and well-organized no-fault newsline on this case as well. Now here, in February of 2020, the plaintiff filed a complaint for PIP benefits related to the respective accident. A year later, and then ultimately 2 years after the accident, one of the providers that plaintiff granted an assignment to, Focus Imaging, moved to intervene. Smart moved for summary disposition as to the Focus Imaging's intervening complaint, citing that the 1-year back rule, MCL 500-3145, barred their complaint. Essentially, they said because Focus Imaging could not relate its intervening complaint back to the date of plaintiff's original complaint, that their summary disposition was proper. Smart then filed a separate motion for summary disposition as to plaintiff, arguing that claims associated with providers to whom he had already executed assignments were barred because plaintiff was not the real party at interest in respect to those claims. So there's 2 MSDs at issue here. One MSD as to the intervening provider, Focus Imaging, saying that the 1-year back rule barred them, and then the second motion for a summary disposition as to the plaintiff, saying that the already executed assignments were barred because plaintiff was not the real party in interest with respect to those claims. Ultimately, the trial court denied both motions. However, as to the 1-year back rule, the Court of Appeals panel noted that Focus Imaging intervening complaint was clearly too late to preserve the bills at issue, again 2 years after the subject accident and 1 year after Farah's original complaint. As to the next MSD, the panel considered plaintiff Farah's ability to pursue the bills that he had assigned back to the providers. So because the Focus Imaging bill has been barred, the defense here was concerned that those bills would now be claimed by Farah, the plaintiff. But the Court of Appeals found that the plaintiff here could not pursue those bills because plaintiff executed assignments to this provider. So again, this is a pretty interesting case and a win for the good guys. Now, moving on to trending topics in PIP litigation. Again, I wanted to discuss some litigation management strategies for pre- and post lawsuits, so before a suit is filed and after. Now, for some pre-suit red flags, and by no way is this list exhaustive, but what I've seen in practice, unlawful treatment, and unlawful treatment could mean a variety of things, but recently we've seen things such as the provider not having a license, the provider not adhering to laws regarding how health care services are provided to an individual, their solicitation. So a provider or a representative of a provider soliciting a claimant immediately after an accident. We've seen a lot of that. Any type of fraud in the procurement of an insurance policy, issues of garaging the vehicle, issues of this is really a vehicle for someone else, but the insurance is in the claimant or the named insured's name. And that also kind of falls under the material misrepresentation arguments. So any material misrepresentation can be used as a defense if the insurer had have known that information and not provided coverage or not provided the insurance contract. Also, excessive treatment when a claimant has mild injuries. That's one we've seen beefing up lately, especially with fee schedules. The more treatment, the better. And then that creates red flags when you have this, low speed rear end accident, but this claimant is seeking treatment 5 days a week, open-ended treatment forever, and is excessive. And you normally see that with like the usual suspects, which I also have on the list here. So you'll see the claimant get into an accident and then treat with 7 of the same providers. And then you'll see another claimant that got into an accident around the same time, treating with the same identical providers. And sometimes you'll even see the medical records looking identical, and just the only thing changes is the name and the date of the name and the birth date of the claimant. Now, also surveillance. When you see these red flags, you may want to get some pre-suit surveillance, which is always helpful. I've almost never seen a situation where it's like, this was a total waste of time. Even if you don't get any information, or even if you don't catch the claimant lifting a heavy box, or I've caught people, climbing trees and claiming that they couldn't walk. But surveillance, even if you don't see those things, provides a view for litigation, for attorneys like myself to have eyes on the plaintiff, to know what type of activities the plaintiff or claimant does in their day-to-day practice, see the claimant walking around and how they interact in their own environment, which is extremely helpful when you're deposing that claimant, and this background information about them and the layout of their home, or where their job is in connection to their home, and now they're saying they can't lift more than 5 pounds, or they can't drive more than 5 minutes, but you have this pre-suit surveillance that took place that has them doing all of those things, which helps you to determine what type of claimant or plaintiff you're dealing with in that deposition, which enables us to gather more and more information. So those are just some of the red flags and how to deal with them. Like I said, it's always important to get surveillance when you have that inkling. It's important to read the contracts to know what constitutes as a material misrepresentation. Now, the law on the material misrepresentation, as we know, has been evolving. But even if you're not able to get a claim or lawsuit dismissed on a motion for a material misrepresentation and procurement of the policy, it almost always drives down exposure and enables us to resolve at a more reasonable amount than it would have if there had not have been surveillance, if there had not have been a material misrepresentation, because the plaintiff does have to think about that. They do have to think about, what if a jury of this person's peers, a working class jury, doesn't like that this plaintiff is misrepresenting these things and then trying to seek all these benefits from them. Now, I did want to highlight MCL 700-492, which indicates that, except as otherwise provided, a healthcare provider or other person, knowing that the information is misleading or inaccurate, shall not intentionally, willfully, or recklessly place or direct another to place in a patient's medical record or chart misleading or inaccurate information regarding the diagnosis, treatment, or cause of a patient's condition. Violation of this subsection is punishable as follows. Now, that is important here, and this is relating back to the unlawful treatment red flag. You'll see, or in my practice, I've deposed physician's assistants that were informed that no matter what a patient's injuries are, to automatically refer to physical therapy, open-ended physical therapy, to automatically refer for MRIs at the specific provider. And like I said, you'll see that in situations where the medical records look almost identical, with the exception of the change in a person's name or their date of birth. And deposing that specific physician's assistant that I'm thinking of, she blatantly informed us that it did not matter. Those were her instructions. And that was a case where we were able to depose the physician's assistant. But in order to see this type of pattern, it should give you, the red flag should go up when you see these identical medical records with these usual suspects. And then you start to wonder, you read the record and you wonder, which of these people can I depose that may be okay with talking about this information? And you would be surprised, regarding a deposition or an affidavit, especially if that medical provider or, for example, PA is no longer with this company or with that treater. And again, pursuant to MCL 500-3157, only treatment that is lawfully rendered, including being in compliance with licensing requirements, is subject to payment as a PIP benefit. And again, that relates back to unlawful treatment, which is kind of a big one this year with the rise in the providers and the assignments. It's important to figure out ways to combat all of the provider lawsuits that we have been seeing an influx in since Covenant. But here you'll see providers opening up these new facilities without adhering to the proper licensing requirements. So that's why it's always important to do that discovery early on as to these providers and figure out what they're supposed to do with regard to their licensing requirements. And then if you find something that isn't appropriate, then you can always file that motion for summary disposition once litigation has begun. But for pre-suit, if you are an insurer or an adjuster and you're trying to negotiate pre-suit, it's an important thing for you to know, if you're trying to resolve it pre-suit as well, that this can be a defense to litigation. If you want to resolve it early on, use this as one of your own defenses. I think I've been talking about how to do these things during discovery and motion practice. But if any of these red flags you have going on right now in some of your pre-suit or post-suit, or cases that are in litigation, and you want to discuss a more in-depth idea on how to handle the discovery or motion practice in them, always feel free to contact me. I'm open to any discussion, and thank you for the individuals who did suggest this topic. I have a few more that have been suggested recently as well, so I will talk about those in next month's My PIP Monthly. And in the meantime, if anyone has any questions and or concerns or would like to discuss any of these ideas or topics in further depth, please feel free to contact me. Thank you.